Hello and welcome to our Financial Literacy Education series, where we help you get a better understanding about your money, help you become more engaged with your money, and help you make better decisions about your money. My name's Corin Jacker, I'm from Priority One Wealth Management Group. In today's episode, we're going to focus on what happens on death and transferring your assets to loved ones in an efficient way. But we're also going to include a discussion of what happens when you no longer have capacity to make your own decisions. So let's start with wills, first of all. Now, to get a bit of an understanding of some of the terminology we're using today, we're going to look at two main documents in terms of estate planning. The first one is your will. Now, your will is a document that only becomes in play when you pass away. Until then, it has no authority or no impact whatsoever. The key roles that occur in the will that most people are familiar with, the first one is the executor. So the executor's role is to gather all the assets, establish any liabilities, and distribute those assets to the beneficiaries listed in the will as outlined in the directions of the will. Now, an executor has no authority while somebody is alive. So just because you're somebody's executor doesn't mean if something goes wrong with the loved one that you're dealing with, that all of a sudden you have authority. It is only valid once that person passes away. So some of the things to think about when making a will. So the first of all, it is essential to make sure that your assets are actually distributed the way you want them to be. And the other thing though is to consider what happens when those assets are distributed in the way you want them to be. So the first thing to look at is things like tax. So what is the implications from a tax perspective when these assets are being transferred to loved ones? And is there a different way to do that? A quick example there is if I've got a couple and they've got some retirement income streams like an allocated pension or any superannuation fund for that matter, if they pass away, if it goes to a spouse, it is tax-free, generally. If it goes to adult independent children, they can potentially pay tax on it of either 15 or up to 30% plus Medicare levy, depending on the components. So it can have quite a significant implication depending on where the money goes. So tax is an interesting one to consider. The other thing when talking about your will is you need to think through, are the beneficiaries in the position or should they be in the position to receive the inheritance that you're giving them directly? And there could be many reasons why it may not be appropriate for those beneficiaries to receive those funds. There could be marriage difficulties. They could be bankrupt and have creditors. They could be just not very financially savvy and might be spending all the money. So there is some mechanism that can be put in place, like a testamentary trust, that can effectively provide the assets to the beneficiary, but with protection around it. So it can protect them from marriage difficulties, bankruptcy, and even from their own bad spending habits. So think through those beneficiaries and what the implications are from their end if they receive the money. The other common thing that we see a lot at the moment too is that when people pass away, which could be in their 80s or 90s, their children themselves are actually in their 60s and 70s and are retired, perhaps financially independent already, have things like Centrelink, and getting an inheritance can actually impact all of that. And sometimes it's those people receiving that money where their preference might be that they prefer it to have gone to their own children who might be in their 30s and 40s. But because they're in receipt of the money and then give it away, that can have severe Centrelink implications. So again, we need to think about who's getting this money and is that the right thing and is there other ways to do it? The second one we want to talk about today in terms of documents in a good estate plan is the power of attorney. And again, this can get a bit confusing for some people. So some people think, as I said before, that because they're nominated as the executor on the will, they've somehow got this power of attorney already covered, and they don't. A power of attorney is a document that enables somebody to make decisions on somebody else's behalf. Now, it becomes into play under certain circumstances, and you can make a power of attorney to come into play under different times. So I can make a power of attorney for a time frame. So for the next 6 weeks, I can give someone authority to look after my affairs. So let's say I'm going overseas. That gives them the authority to speak to the bank accounts for that limited period of time. Okay? I might give someone the power of attorney just to come into play at some date in the future. The most common power of attorney arrangement we're focusing on today, though, is what we call an enduring power of attorney. And what that simply means is that when you make a power of attorney arrangement and it's nominated as an enduring power of attorney, what you're saying there is that I'm giving this other person the authority to make decisions on my behalf only when I no longer have capacity to make those decisions. So while I have capacity, while I'm able to make my own decisions, that power of attorney document is invalid. So that's the most common thing we see in estate planning. An enduring power of attorney that only comes into play when you no longer have capacity. Now, one of the things about power of attorney arrangements, and the same with estate planning, is it can differ from state to state. In the Victorian example, where we're based, is they've got 2 nominations of power of attorney that you can make. So one covers personal matters. So that could be things like deciding on aged care accommodation. The other one is financial matters. So that can be dealing with superannuation funds, bank or insurance companies. You can nominate different people to have those different decision-making capabilities. You can nominate the same person. The good thing about having a good power of attorney in place is it does take away a lot of the ambiguity that can occur if something happens to somebody and they're not dead, so the will is no relevance whatsoever, and other people, whether it be financial institutions or hospitals or aged care providers, need to know who's making the decisions. And without this document, and particularly if there's family conflict, it can become a very complicated arrangement and a very difficult arrangement to sort out and solve in a particular situation where time can be of the essence. So they're the 2 documents I want you to consider in your estate planning. So the will, you want to consider who's going to be your executor, and you want to consider who's going to be your beneficiaries. You want to consider, is it appropriate for those beneficiaries to receive the money directly, or should there be some kind of testamentary trust to protect them? And you also want to consider things like tax and social security and the implications of what happens if you pass away, where do the assets go, and is that what you want to happen? You want your power of attorney in place, which obviously is a document that comes into play if you can't make decisions but you're not dead. So that's really important, and it's becoming more important these days where we're living a lot longer but not necessarily having the capacity to make our own decisions. The other thing to consider with estate planning that we also talk to people about is just some of those decisions around if you do happen to be in a situation where you can't make decisions and you're still alive, or you do pass away, what are some of the wishes you want to have happen? So do you want to be buried or cremated? Do you want flowers at your funeral, or do you want a charity donation, or do you want flowers, or do you not want any of that? Do you want to be buried in a cardboard box? Because if you don't make those wishes clear, it can be a very stressful time for loved ones to know exactly what your wishes are. And if something happens to you and you haven't passed away, it's good to also understand what your wishes are in terms of the care that you'd like to receive under different circumstances. And I'd also like to make a final note that if you haven't already in relation to this area, become an organ donor and tell your family that that is what you want to be. Thank you. Goodbye.